absolutely thrilled because we have two attorneys who practice in town but are also involved and engaged in several boards. And so their expertise, both from a legal perspective and from a board member perspective, I thought would be very helpful for you guys today. So first we have Ms. Linda Hoffman, who I am privileged to work with at United Way because she is on our board of directors and actually chairs our Community Impact Committee. And then we have Margaret Stock, who I am privileged to have been on a board that she chaired with Rotary a couple of years ago, and she does an awful lot in the community. But Linda is a member of the Carver Darden Law Firm. She's been an attorney since 1985. I don't know how you do all of this, but she's a member of the Louisiana, Texas, and Florida bars. She's practiced in Louisiana and Texas prior to returning to Pensacola in 2001. Her practice involves primarily commercial transactions with a focus on banking litigation and business and real estate closings. She's currently a member of Impact 100 and is on the board of directors of United Way, has chaired Impact 100, and I was privileged when I was at Ronald McDonald House and we were closing on the property to the new Ronald McDonald House. Linda was the one who was helping us out with that whole process and with our paperwork for that, and donated an enormous amount of hours to us. So thank you very much, Linda. And then Margaret Stopp is a shareholder with the law firm Moorhill and Westmoreland. Eventually I'll be able to talk today. She became a member of the Florida bar in 1989, but practiced in Virginia and North Carolina prior to coming to Pensacola. Her practice involves real estate and real property, community associations, landlord-tenant matters, and local government law. Currently, again, all these people you guys get to see today, I don't know how they do it all. She is the president of Pensacola State College Foundation. She's the past president of the Rotary Club of Pensacola, the Escambia Santa Rosa Bar Association, and the Panhandle Tiger Bay Club. She is on the board of Baptist Hospital, the Baptist Healthcare Foundation, Pensacola Country Club, and a member of Impact 100. So to your question about is multiple boards good, you can see that theme will come up again and again as we go throughout the day. And they have prepared a wonderful presentation for you, so I'm going to turn it over to these lovely ladies.
You know, Margaret and I work at different firms, but we are personal friends, so we a lot of times do that chit-chatting back and forth about what we see and what we do. And when we were asked to do this, as I'm sure you all know, the legal part isn't always the most interesting part. And a lot of times people want clear-cut answers, and sometimes there are clear-cut answers, but a lot of times the real answer is in the gray, and it's a judgment call. So we decided today to go through the legal parts of it, but we're going to try to kind of highlight some of the specifics or what we see on boards or what might be there. And then we're hopefully going to have enough time at the end to let you ask some questions about what it might be. So I'm going to let Margaret start with corporations in general.
Good morning. Actually, I was at the Pensacola State Foundation Executive Board meeting this morning, and that's where I came from. And so I've had a dose of board work this morning. This presentation, we're going to talk, as you said, about the legal issues, but it's also geared, to some extent, after looking over it again, it's geared towards what you should expect your directors to be asking you. Sometimes I've seen with staff and executive directors that in some organizations, they get, it's their domain and they resent when the directors ask questions. And I think after our presentation today, this will tell you what the role of your board is and the directors and what you should expect of them. You don't need to be the lone ranger in that organization, as I think some executive directors and staff sometimes feel they are, that they don't have the support of the board. This will give you an idea of what you need to expect of your board members. Generally, just to get started, what are nonprofit organizations? Well, they are for the public benefit. You're supposed to, as a nonprofit organization, benefit the public rather than individuals. You may or may not have members. Most of them don't. You're eligible for exemption under 501c3 and 4, and that's your educational institutions, your art museums, and your conventional charities. Y'all probably fall pretty much into that category. There's also another category of religious. If you establish that you meet the requirements of being a religious organization, you're automatically 501 organization with tax-exempt benefit. Then There's a mutual benefit organizations. That's examples of that would be your country club, your homeowners association, your trade associations. And I do a fair amount of work, excuse me, with homeowners associations. Just call me Senator Rubio. And I don't know that many of you fall into that category today. I think you're going to be in the charitable organizations. Now, the corporate body is the one that has, the board has the power to run the organization. It's the one that hires the staff. It's up to the directors to do that, to hire your executive director. Now, executive director may have the power then to get other staff members, but it's still the very powerful board that runs that organization. That's what their role is. Oh, thanks. I got to remember to click. All right, thanks, Linda. Individual directors. They're not supposed to and should not and don't have power on their own. This is a collective body. The power of the organization is in concert as part of the board. It's the board that has the power, the board that votes and does things.
You know, one of the things from a director's point of view, I think, I have been on boards for a long time, even before I came to Pensacola. And I think a lot of times, executive directors can sometimes feel this is their company and their baby because they're so passionate about it. But you've got to look at it from the directors, that legally they're the ones that are responsible for it and running for it. And so I've had times where I've been on a board where when I asked questions that I felt I needed to know, I kind of got some resistance that someone thought I was trying to step into their box. And I think it's important as a director, for those of you who are the directors, to understand that an individual director is legally accountable for actions on a board. So you can't take it personally that they're wanting to know information, because that really is part of their duties. And I think that's important to just understand in this whole scheme.
And that's what we're here for today, are the legal responsibilities, because an executive director or staff member can quit at any time, and there's generally no legal consequences barring fraud or some other kind of situation. But if you're on the board, you have the legal responsibility to run that company. You have to make sure that everything that is supposed to get done to keep that entity as it's supposed to be is done. You as a board member have a huge responsibility, or your board members have that responsibility. Again, you could quit tomorrow if you're an executive director. Sure, you can do that as a director or a board member, but again, you have legal responsibilities as a board member, and if that's taken seriously, that's the person who, along with the board, that runs the organization. And let's talk a little bit about individual directors. And this gets to what I heard in the last presentation. It's something of an overlap, but it has a little bit more of the legal overtones and requirements. If I'm asked to be on a board, I want to know the purpose of that board. What does it do? What are the aims? And am I compatible? My personality compatible with that? Do I have the passion for that? That's what your director, a person that you're considering to be on the board, should be asked, and as that person should be reciprocating and thinking those things at the same time. What's really important? Look at the governing documents. It's remarkable to me, and Linda's going to go a little more detail on governing documents, how many organizations don't ever read their articles of incorporation, which is okay. They're usually not, that's your constitution, but all right, I can say, you probably don't even know where your articles of incorporation are, especially if you've been around a long time. But your bylaws, I don't know how many organizations I've been on, and the board's about to take an action, and they'll say, well, that's in the bylaws. And I've got, of course, the lawyer, even though I'm a board member, and that's a whole other ball of wax I have to be careful about on a board, is, well, that's not what the bylaws say. And they'll say, yes, it is. And I'll say, where? I've got them right here. That category of membership is not in the bylaws. Well, we thought it was. Well, don't vote. Well, then they voted anyway. And I'm going, what? And they voted. Well, guess what? The next meeting had to rescind the vote because, oh, yeah, I guess we voted that on the bylaws a few years ago. No. The bylaws are your governing document that should be at hand at every meeting. Every board member should have a copy of the bylaws, be familiar with them. That's where you go to say, okay, if we're going to pick board members, how do we do it? Do we have a nominating committee? What time of the year do we need to meet? That's a very important document that all directors need to have and be familiar with. And if you're looking at these organizations that we're talking about today, you've got donors. What is do I as a board member, do I have the best interest of that donor in mind? No, I don't. I have the best interest of the organization in mind. I don't have a legal relationship with a donor. My legal relationship is with this corporation, with this charity. It's not with the donor. Now, as a practical matter, yes, you want to be nice to your donors. You want to get them passionate about your organization. But as a member of the board of directors, if there's a donor that is making demands on the organization to which they want to give funds that are contrary to the governing documents, the bylaws, the charter, whatever you might have, well, what wins? I'm sorry, the law wins. They just have to give their money somewhere else or come within the parameters and the legal requirements of your organization. So you can't compromise the legal requirements you have as your corporation and what you've been formed to do.
Let me jump in there before you panic and think I've always got to think of my donors. One of the things, as a director, I owe my responsibility to the corporation. I don't have any responsibility dealing with the donors. But if the corporation is 100% dependent on donors, then you're going to make decisions for the corporation in light of how donors would view it. The difference is if you've got that one donor out there who's demanding things, you might need to write them off because of how all other donors react. So you're not sitting in we know that you're not sitting in a legal vacuum where you can't think about donors. You're going to think about them because that's where you're going to get your business from. But you've got to think of it from the source of how do the donors affect this corporation and what's best for the corporation. That's kind of the theme you're going to see in a lot of things. You've got to be thinking what's best for the corporation and how to do this.
And if you talk about changing your board of directors, or if there was some discussion of that in the last panel, there is power not just to ask a member to leave, but if you know your bylaws say terms a year, terms 2 years, terms 3 years, know when the terms are up. Because sometimes time takes care of things. And if there's a board member that's a problem for whatever reason, but their term is up in 2 months, why just send them a nice letter? Thank you so much for your service. We've really appreciated having you, and you're done with them. So there's those kinds of things too that your documents can be your friend. Make sure you have a chart that you know when board terms come up. If they're staggered, people come on, they come off. Keep a chart that shows that you know. So if a board member says, and a board member is part of the package, should know what their term is up front. This is a 5-year term, because I've been on boards from anything from a 1 year to, I think the longest one was a 4-year term. Panhandle Tiger Bay Club, I believe, was a 4-year term. 2 4-year terms, 8 years, long time you could be on that board. But you need to know what those terms are because the bylaws can be your friend in running the organization and they are the governing document. If you don't like the bylaws or the board doesn't like the bylaws, the board has the power to change the bylaws as long as they do it in compliance with law and they're not doing something that's totally illegal. If the bylaws don't work, change them. But how is that done? Through board action, properly noticed, properly debated. But otherwise, the board, you need to abide by the bylaws. Now, the director, I think Linda and I will probably say this 100 times today. You heard it before, that the director's obligation is to make decisions that comply with what is best for the corporation, not for that individual director. And having been on a lot of boards over a whole lot of years, and if y'all have been in this business for a long time, you've seen directors that make decisions and they're thinking what's in their best interest. They're not thinking of the organization. That's a violation of their fiduciary duty, legal fiduciary duty they have to that organization, and that's a serious matter. And that may have to be dealt with more directly with them. Now, we talked about if you're going to approach board members, you don't just say to them, gee, would you like to be on this board? The nominating committee shouldn't be just sent out to find somebody to be on the board. They should be empowered with documents, whoever's role it is to get those board members, because the prospective board member needs to say, you need to know, they need to know right off the bat, what's the term? How am I elected? Is there going to be a slate and I could be left out? A lot of people won't be on a board if they do that. They want to know what the process is to getting on the board. They should have copies of the governing documents early on in the process. You may not want to give your bylaws right away, but make sure that they know the date of the meetings, what day of the month, what time, because they need the person you're asking has a schedule and is on other boards. Get that. Make sure that your people who are looking for other board members have this information, that they know, that they can articulate what the purpose and mission is of this organization when they're looking for these board members. Always something I do as an attorney, anytime I deal with a corporation or an entity of any kind, I go right to the Secretary of State's website. Is the organization active? Did they remember to file their annual report? Because if I'm asked to be on a board, I'll go look at that to just see it, because my own clients, I do that periodically, because no matter how much you remind them, they don't always remember. But that tells you a lot about an organization. If they can't even keep their status with the state current, I'm running the other way, okay? You've got to make sure that that legal aspect's taken care of, and I know that's probably the responsibility of many of you in here as the staff person or executive director to make sure that that annual report is filed with the state. You should have the people empowered to say, these are the members of our board now, these are some of our key staff members, these are our officers that we've had in the past. That basic information should be provided to prospective board members, and believe me, they'll appreciate that a whole lot. It'll save time, because you won't get them on the board and they'll say, oh, you didn't tell me it meant the third Wednesday of the month. I've already got another meeting at that time. So empower the people that are either on your nominating committee or whoever's responsibility is by making sure they have that information. Now, we'll come, again, this is the current, I think the recurrent theme in what we're talking about, the duty of care. What do you expect your board of directors to do? The board of directors has to act in a reasonable and informed manner. They have to participate in the decisions of the board. They're supposed to have oversight. They're supposed to make sure the executive director and the staff are doing what they're supposed to do. And I think it'd be naive of anybody in here that hasn't seen where executive director or staff has not done what they're supposed to do, and that board then has to take the action to move that executive director out and to fire that executive director. And that's something, though, that is the board's responsibility to do, and it can be very hard for a volunteer board, because as a volunteer board member, you want to be a part of that organization. You don't want to worry about the day-to-day stuff. But if you get wind that there's something going on, that this executive director is not doing what that executive director is supposed to be doing, your board member should not be burying the head in the sand. That board should be talking, the board should carry on that, get together, talk about that issue and deal with it, because it can go on and on and on, and then there can be a precipice. There's at least one nonprofit in this organization is no longer here that died in 1989, and it was because of a board that just was going along its merry way and it went over the cliff. And it's no longer in Pensacola, a great organization.
But I will tell you, the duty of care, someone asked before, what do I have, am I legally required to present to my directors? There's nothing in the statutes that says you need to present this and this and this. It all comes down to, in light of your corporation and what you do, what do your directors need to exercise reasonable business judgment and approve everything. And just to give you a brief example, when I was back in the early Impact 100 days, they had $267,000 was their budget. Well, the thought of approving financial statements was kind of ridiculous, because all they owned was $267,000 again in a bank account, and it didn't come out until the grants were awarded. So we implemented a different procedure of every month we looked at the check statements. Well, that gave us the control. No one was writing checks, the money wasn't going anywhere. It didn't have to be financial statements. So you need to look at your business entity and say, what do my directors need to know to feel comfortable they're running the company or approving things right? But there's no magic list you're going to find in the statutes that you need to give them A, B, C, and D, and E. It doesn't exist.
All right, so now, what should you expect of your board member? You expect that your board member will attend meetings, and that was touched on by this panel, how that can be a problem. But again, when the board member is brought on, the importance of that needs to be emphasized right off the bat. It can be part of your orientation. It can be part of your bylaws. Again, your bylaws can be your best friend. You missed 3 meetings. It's been great having you. See you later. Okay? Use your bylaws, because attendance at the meeting is critical. Attendance at committee meetings when they're appointed to a committee, because it's a responsibility of that board member to be informed, and how can you act in the best interest of the corporation if you're not informed about what's going on, and if you're not engaged in what's going on? Because that board member is expected to receive information that if you're going to start a campaign, or you're thinking of buying a building, or whatever, you're thinking of getting this grant, but you need the board to talk about this, well, that board needs to be fully informed. If the board member is not sitting in the meeting and getting the information that you should be providing to that board member, so that board member can use that board member's independent judgment to make those decisions, that board member is not acting in the best interest of the corporation. How can they? They're not there. They're absent. That's impossible. And that's where dangerous things can happen, because then you can have a select few making decisions. It becomes easier for a staff or an executive director to snooker a board. And I don't mean to offend anybody, but I've been doing this a long time, and I've seen where staff has snookered boards for a long time. Sometimes it's because, again, you're dealing with volunteers. It's frighteningly easy to snooker a board, and I've seen it too often. Now, I know nobody in here as a staff or an ED would ever do that, but it can be done. I shouldn't tell you could do that. And then things come to a vote. There's discussion, and that board member has to vote, and it can't be just, the vote can't be solely on the basis of, oh, I like what Linda says, I trust Linda, she says it's good, I'm just going to vote for it. That's not the role of the director. The role of the director is, I appreciate what Linda has to say, but I also appreciate what Joan has to say and John has to say, and you're taking all of that information in. You're relying on reports. If you get a professional report, an appraisal, that you look carefully at that appraisal, ask questions about the appraiser, or you get another type document like that from a professional, you have the right to rely on that information. But let's say it's an appraisal and your expertise is appraising, and you look at that appraisal and there's an assumption made in it that you question. Well, you have the right to rely on your own personal knowledge and say, wait a minute, this appraisal is, if there's an assumption the appraiser made in determining the value of this property, I don't think that may be correct. I think we need to look into this more. So it's okay for board members to bring in their individual knowledge. That's what you like to have, and to help everyone understand what's going on. But again, it's a collective, and everybody has the responsibility to judge what's in the best interests of the corporation by taking in all of this information. Okay, we're going to speed it up a little bit. She's right. Again, this is all duty of care, and I think we've been over this a whole lot. Expect your board members to ask questions. If they don't, I liked what I heard earlier on the panel. Go around the table. The chair can go around the table and say, what do you think about it? What do you think about it? And I think that's a good way to engage your board. A board's also going to want to know about your ENO policies. Well, they all underlyingly require that you act in the best interest of the corporation and do what you're supposed to do. This slide here talks a little bit more. Again, you're going to have this to take with you in your packets, to how you can run things in your meetings. There can be delegation of operations, but the board still exercises overview. Now, oversight. If you see a red flag as a board member, you have a duty to go check out that red flag and make sure that, oh, it's okay, it's not a problem, and you should expect your board members to do that. This is what you'll see in legal proceedings. When you see cases, and unfortunately there are cases out there with nonprofit organizations, the directors must exercise care that an ordinary prudent person would exercise in a like position and under similar circumstances. That's the business judgment rule. That says you can rely on what you're getting from other professionals. And if you do that, you as a board member are pretty much protected in your decision. And again, there is a statute in Florida that provides immunity for directors who satisfy these duties, but I would never sit on a board myself if there were not an ENO policy, because that policy is not really, what does it provide? It provides legal services. Anybody can sue anybody for anything, because you'll always find a lawyer who will do it, or a pro se person who will do it. And you need that insurance policy to defend against it, because just defending against a bogus claim is going to cost money. So the organization must have that policy. I think
I'll say though, I've sat on boards without it because I couldn't afford it, so that's just
a risk you take.
But I will say, a lot of this legal stuff can sound overwhelming. It's not that bad when you get adjusted to it. But one of the key things to remember, the main reason you're doing this legal stuff is if something bad happens. It's kind of like if you're a business person on a contract or an employment agreement. You get it at the beginning. You never look at it until there's a problem. And all this stuff we're telling you is because if one day something bad happens and someone challenges it, you're a whole lot better off if all this legal stuff is in place. And that's one of the key things to remember. Lots of this stuff will never happen, but if you're in the 2% chance it happens, you're going to be in very good condition if you pay attention to this. And when people get on boards and they don't want to be on because they're afraid they're going to be sued, especially if you don't have ENO insurance, as long as you're on the board and you exercise prudent business decisions and you're not reckless and you don't exercise, you don't have conflicts of interest, you don't do things for your personal benefit, you're not going to lose. You're not going to have liability. So it's the conflict of interest that's the problem, and it's not exercising your business judgment. And that's the bottom line. Did I give my directors enough information so they can make a reasonable business decision?
And let's talk a little bit about conflict of interest, because this is a huge issue with many boards. I have served and continuously serve on different boards. I also have a business, my law practice. You know, I may belong to a church, I may have this, I may have that, and like any board member does. Well, in Pensacola, you see yourself coming and going all the time. It's a small town. And so what about this conflict of interest? Does your organization have a policy? Do you? You should. If you don't have what is your board member supposed to do? If you're considering getting certain services to maintain the property you own, and you're doing landscaping companies, and you're doing this, and one of the board members is a landscaper who actually put a bid in to do the work. How do you resolve that? That's a conflict of interest, isn't it? Because that vote, that he or she will get a financial benefit as a result of that vote if they get the landscaping contract. Well, how do you deal with it? Well, if it's not in your bylaws, then okay, fine. Is it in your conflict of interest policy? Because you all have conflicts of interest policy, right? If you don't, when you leave here today, you can Google it and you can find yourself some good models for conflicts of interest policy. And if you're filing the 990, you darn well better have a conflict of interest policy because it's required as part of that process. What are conflicts of interest? How can they come up? I've seen it where, in numbers of ways, that you have a person on a board here, they hear what's going on, it's going to have an impact on another organization, company, or business, or whatever. They leave that board meeting and they go and say, guess what they're doing there? And they're going to be sending you a letter about this, and you need to know about that. Is that right? No, that's wrong. That's wrong. Are they acting in the best interest of that company whose board they just stepped away from to do all that? No, they obviously have a personal interest of some sort or a loyalty outside of that board of directors. And it happens. I've seen it happen. That's a classic conflict of interest. Now, if you have a vote coming up on a matter, you need a quorum, that person who has a declared conflict of interest pursuant to your written policy can state, I have a conflict of interest because I have a financial interest in the outcome of this vote. They can be counted as part of the quorum, but they can't vote. Don't let them vote. That's one circumstance you don't want a board member to vote. Otherwise, board members always have to vote. And don't you love it when you get a board member that says, well, I just don't like that, and I'm just not going to vote. No, board members have an obligation to vote. Yes or no. None of this abstention stuff. The only time you do get to abstain is if you have a declared conflict of interest, such as a financial conflict of interest. But again, as a practical matter, they can be counted towards the...
And I'm going to make one comment about, I have personally offended executive directors before in my prior life.
No.
Once or twice. But I think as an executive director, you need to think of your personal interests a lot of times. And I know I had a situation where my organization was going to do another contract or a joint venture type with another organization, and the two executive directors were related. I asked our executive director to leave the room. And I highly offended her, but to me, there was such a conflict of interest that people in the room weren't going to say the same things. I think if your appearance, or if the appearance of any other director in the room is going to affect discussions, you should just ask them to leave, and no one should be offended by that. Because that way you're getting all the conversation going without having it appear that someone couldn't say something because someone else was in the room. So use that recusal and make it part of your board. I mean, I think it helps everybody.
And then that gets to confidentiality. Again, that issue of your board members should not be leaving the meeting, your staff shouldn't be going around and talking about what the organization is doing, because many times it's strategic to the organization. You should also have a policy that you don't talk to the press, except how do you talk to the press? There should be one in place that all communications go through the chair or the executive director or whatever. Would be the face of it. And then, what are the rights of your directors? They do have the right to contact the ED and to talk to other board members to get information. They shouldn't be talking to the rank and file staff, and that's a hard thing. Again, it should be in your policies and how a director gets information. And this is for run-of-the-mill. I'm not talking about running down a red flag. They have the right to inspect the corporate records, to have ample advance notice of the board meetings. Nothing annoys me more than when I walk into a board meeting, here's the agenda, and here's the backup that thick, and we're going through it right now. And I can't read fast enough. Don't ever do that to your board members, and your board members should be saying to staff, don't ever do that to us. We want this ahead of time because we need to, anything of any substance, we need to read it ahead of time so that we can ask the questions we need to ask. And of course, if they want a dissent, that's fine, and their vote would be a no, that's great. And then if your board member says, hey, I need the minutes for the last 12 months because I'm new, I'd like to know what's been going on, give them the minutes. That's what, and the minutes, I'll turn this over to Linda and let her get into some of the other
We've heard about corporate or government documents. These are really the two, the articles of incorporation and the bylaws. Articles of incorporation, for most corporations, are very short. They're filed with the Secretary of State, and they're your master documents. Bylaws are more your working documents of what you use day to day. Florida statute says what has to be in your contents, your corporate name, your purpose, your statement. It's usually very short, but a lot of nonprofits have a lot of detail in their articles. I've seen nonprofit articles that are 5, 6, 7, 8 pages long. If you have one of those long ones, and there's nothing wrong with it, you need to know what's in your articles because it can affect your day-to-day organization and what you do. All these other things listed, the directors, the distribution of assets, those are all things the statute specifically allowed you to put in your articles. So they can be as long as you want them to be. Those are filed. The articles really trump everything because that's what everybody has access to. So if your articles say you can have 10 board members, then your bylaws shouldn't say you have 14. You've got to go amend your articles. It's easy to amend them, you just got to remember to do them. Bylaws are the provisions for regulating and managing your company. They tend to have more of your day-to-day organizational stuff. They usually name the officers, when your directors' meetings are, your annual meetings, some of your key issues that you might want for your corporation. You got to keep another requirement for legal records. You've got to keep complete books and records and minutes of your proceedings in your board of directors. That's what's required under the statute. If you have members that are entitled to vote, you need to keep those in your annual reports. Need to be filed every year with the Secretary of State. If you don't file them, you can get a lot of, it goes from $120 to $550 to file them, and then you can ultimately get dissolved. Minutes of meetings, that comes up all the time. There's really nothing that says in the statute what you have to have. You have to have minutes. They're designed to protect your corporation and show you're making good decisions. It's designed to show you're complying with your policies and procedures, to show you're exercising and meeting your fiduciary duty and care, and you're using the process. So in other words, your minutes should be largely self-serving. They're to show what you're doing. They're to help you so that if somebody comes back later and says what you need to say, this is what we did, so write them so that somebody coming in after the fact looking at them would get a good feeling for what you did. I think you need to use caution when you go into a lot of debate about issues. If your minutes start detailing debates and who says what, then you better do every single thing. And I generally recommend you don't do that kind of detail because that will get you further into trouble when you start saying Mary said this and John said this. Instead, said there was a 40-minute conversation with a lot of discussion and the pros were this and the negatives were this and we ultimately resolved it this way.
And there's a motion that is, should have everything in it as to what the decision of that board is. There's a second, any further discussion, and then there's the vote. And so you're, again, you don't want minutes that go on forever. Robert's Rules of Order say there was discussion on this matter, there was, and say the motion, and say, that's really skinny if you read Robert's Rules of Order. Again, make them the discussion part as long as you need it to be, but don't be too long. It'll get you into trouble later on.
I'm asked a lot of times who should take minutes, and again, there's nothing that says who needs to take minutes. A lot of times it's going to be someone internal to your organization because no directors want to take them, and that's fine, but your secretary or whoever your director is responsible for it should be taking their own notes so that when they review the minutes, they know they're right. Don't be just a rubber stamp, because if someone ever questions what your organization did and they go back to your minutes and the minutes aren't right, it's very hard to say, well, that's not really what happened. We really had a discussion and I remember it, and then everybody goes, well, how can you say that? These were the minutes and they were approved. You can't counter that. And it looks very, very bad when you get into it. I personally think if you keep handwritten notes of what happened, once you write your minutes, you trash the notes.
Or your recording. You don't want to keep those things, because later on, if there's litigation over an issue, and I've been involved on the professional side with defending litigation involving a nonprofit, if you have a tape recording or notes and they don't match the minutes and things that are said there, it's a mess in the litigation, because it just gives more fodder for the side that's opposing what the board did. So I agree with Linda that those things should be destroyed once the minutes are approved by the board.
One of the other things we were asked is, how much do directors care about job descriptions and contracts? And again, there's no legal answer to that. It comes back down to that business judgment rule. I always look at it that if I'm making these approvals and I've got an executive director reporting to me, how do I evaluate them unless that executive director has a job description? So as a director, I pay attention to that. I may not pay as much attention to the job description under that executive director, but I'm going to be asking the executive director, how can you evaluate your direct reports unless you have job descriptions? So I'm going to know the job descriptions are there. I'm not going to pay the same detail to those job descriptions, but I should know they're there. Because if this was my personal company, I want to know they're there and everybody's running accordingly. My last thing that always causes me concern is lawyers on board. Of course, it's kind of personal to me, but I've been in a lot of situations. When I'm a lawyer on a board, I'm not there as a lawyer. I'm there as a board member. So when you ask me your opinion on a legal issue and I say it, you don't have any attorney-client privilege. And if you ask me about a contract and I say, I don't think that's a good idea, I wouldn't do it. But then you decide to do it and later get sued, somebody can go back and have a deposition and say, what did Linda Hoffman say? And when they say, well, she told us not to do it. They can say that, and it's written that way. Now, if someone asks and needs a legal opinion, I can go off on the side and I can open a file and I can give you a legal opinion as a lawyer, and I can label it attorney-client privilege, and it can go in your minutes, attorney-client information, Linda Hoffman said this, and when they sue you, nobody can see that information because it was subject to the attorney-client privilege. So I think if you had a legal question for a lawyer on a board, you need to ask it as a legal question and get them to give you an opinion on it and mark it attorney-client privilege. I've seen too many times where lawyers say things on boards, and it's like, ugh, you don't want that to be said. Whereas the lawyer wouldn't mind opening up the file for you and giving you the answer, and then it's all subject to the privilege. So,
and an alternative to that is I'm on one board and I say, y'all have an attorney. I will give my opinion as to certain things, but not a legal opinion. Go to the board's attorney. Get a legal opinion from the board's attorney, and that's how this one particular board, how I handle that one. But there's two ways to do it.
So that's where we are. Andrew, I don't know how much time that we were.
We knew we were going to be over, so you guys have done great, and I feel horrible that you felt like you were being pushed.
Well, no, but I mean, you could talk, you know, there's a limit.
And it's very, very good information. I've already had a couple of folks who've had questions, and I know Doug's got one right now.
Operating in the sunshine. And what guidance you would give?
You operate in the sunshine?
I'm asking, do we as nonprofits, is it assumed that we're all operating in the sunshine?
No, the Sunshine Law and the Public Records Act, what is included in that only applies to companies that have a governmental process. For instance, the Area Housing Commission, the Pensacola State Board Foundation, the UWF Foundation. Those kinds of organizations are, in a sense, quasi-governmental, and so they operate under the Public Records Act and the Sunshine Law.
How is that determined?
by law, by the statute, there's two provisions, Chapter 119 and Chapter 286. It's clear whether you are involved or not. You've got to be a public body. The council, the county commission, the city council, or one of these other organizations that have been determined to be sunshine organizations. Area Housing Commission is a quasi-public body, as are the foundations based upon Attorney General's opinion several years ago.
You probably ought to know.
Yeah.
I mean, if you have any doubt, like if you are funded primarily from government money,
Correct.
you might be subject to it.
We're acting that way.
You should definitely get a legal opinion of whether you're subject to it. I would never operate under the sunshine law myself.
Believe me, I second that because I do a lot of sunshine. I know sunshine more than I would ever like to disclose because I've been involved in some sunshine issues over the years. Other questions?
If you do have questions, again, if y'all will forward them to myself or Melissa, we'll send follow-up questions to them like we did last time and get the answers back to you. And thank you, ladies, very, very much.